Good afternoon, everyone. My name is Lisa White. I am CML's Membership Services Manager, and it's a pleasure to welcome you today to this webinar. We appreciate it. Those of you, well, we don't have any elected officials on this webinar, so I'm not even going to talk about Muniversity because this is one of our webinars intended for municipal attorneys. So we certainly appreciate you participating and being with us today. For those of you not familiar with the webinar format, you'll see a control panel to the top right of the screen. You have an orange arrow to the left of the panel which will minimize the entire box. All of you will be muted for the webinar, but you can certainly ask questions by typing them into the question box on the control panel. We will, however, answer questions at the end. We are also recording the webinar and will post it to our website tomorrow sometime. That way you can share the link with a colleague who perhaps wasn't able to participate in the live version, as well as perhaps review it if you missed something else as well. We do have 2 CLEs approved for this webinar, and I'll share with you how to go about getting those credits afterward. Before I kick it off to our presenters, I'd like to turn it over to my colleague Diane Criswell. She is one of our legislative and policy advocates who oversees tax issues for CML, and I'd like to have her say a few words.
Thank you, Lisa. Hello, folks out there in Colorado. I just wanted to kind of set some context. Some of you likely know we represent a membership that is sales tax reliant. For most of our membership, over 70% of their overall funds are generated by sales tax revenue. Just as a side note, we do have some members that only collect sales tax. We also, on the other end of the spectrum, have members that only levy a property tax. So here at the League, I would say of my issue areas, of which sales tax is one, it is the most important issue area in my portfolio. For our home rule jurisdictions that self-collect, we've got 69 of those, and in the sales tax area, there are a couple, 3 things going on at the legislature that I thought I would bring up. We haven't seen any bills related to sales tax appeals this year. You all are aware of the bill last year related to posting bond for a tax appeal. But it's something, as far as the appeals process for local taxes, it's something that we're always staffing. The other issues that are out there are kind of finishing up standardized sales tax project, a project that probably most of the folks online have participated on at some level within their jurisdiction. And then I thought I'd mention one last thing, which is the Department of Revenue is doing their rulemaking on the 2010 Amazon law that was appealed all the way to the U.S. Supreme Court on the Commerce Clause issue, remanded to the 10th Circuit on the jurisdictional issue, and the U.S. Supreme Court denied the review of the remand in December. So that's kind of what's going on in the legislature, but just I am new to this issue area at CML, but not new to state and local tax, and I'm happy at any point to be a resource to you on tax issues. So with that, I'd like to turn it back to Lisa, who's going to introduce the speakers.
Great. Thanks, Diane. So we're very fortunate to have 2 extremely knowledgeable attorneys with us. Charles Solomon has over 20 years of state and local tax experience. He joined Denver City Attorney's Office in 1999. He advises and represents the Denver Department of Finance in sales, use, lodgers, occupational privilege, and facilities development tax matters, as well as locally assessed property tax matters. He began his state and local tax practice in 1996 at the Wyoming Attorney General's Office, where he advised and represented the Wyoming Department of Revenue in sales and use, mineral severance, and state-assessed property tax matters. Stacy Arzada is currently the Deputy City Attorney for the City of Greeley and has worked for the city since August 2005. Stacy handles a variety of matters for the city, including representing the police, human resources, and finance departments. She received her Bachelor of Social Work degree from New Mexico State University in '93 and her JD from the University of Wyoming in 1997, where she was a member of the Land and Water Law Review. Prior to joining the City Attorney's Office, Stacy was employed as a Senior Assistant Attorney General in the Tort Litigation Division of the Wyoming Attorney General's Office. There, she supervised the Personnel Section, handled employment matters, and professional licensing board prosecutions. So with that, I'm going to turn it over to Stacy. Again, thanks for participating.
Thank you so much. Chuck and I are really happy to be here to present about sales tax appeals for everyone. I just did want to say before we start that we have a few handouts that are available both through the webinar and on CML's website. So if you haven't had a chance to look at those, you can pull those down. So with that, I think we'll go ahead and get started with the webinar. So just in the way of background, there are about 100 home rule cities and towns in Colorado. And I'm sure, as all of you know, that home rule cities and towns are authorized to assess and collect sales and use taxes, and that's through the Constitution. We are clear on the fact, and we all know that the assessment of sales and use taxes is a matter of local concern. So we all can self-collect, we can go through the Department of Revenue to collect, and we can decide what type of sales and use taxes we want to assess in our jurisdictions. And we have a couple of sites there if you're interested in those. In 1963, the statute was enacted, which is the Municipal Sales and Use Tax. And primarily today we're going to be talking and focusing on Section 29-106.1, which is the statutory section that defines the process for bringing appeals from local use, sales and use tax assessments and refund requests. And that's really the statute that you want to know if you're practicing at all in this area. And for better or worse, the appeals from the assessment of sales and use taxes is not a matter of local concern. And so that's a statewide issue. And so we all need to be aware of the statutory sites for that and be familiar with 29-106.1, which is why we decided to focus our efforts today on that statute. So again, everybody, whether you're self-collected or not, you have to comply with the procedural processes set forth in that section. So my tip today is that when you get an appeal, the first thing you want to do is really make sure that you're familiar with that statutory section. Chuck and I have had a good time preparing for this webinar, discussing the differences between a big jurisdiction and a small jurisdiction. And Greeley's not as small as it used to be, but we certainly don't get the level of tax appeals that a big place like Denver does. And some of you out there maybe fall on one side or the other or somewhere in between. And we're hoping today to kind of give you a perspective between a smaller jurisdiction and a larger. No matter what size your jurisdiction, you do have to comply with that statute. And so if you're like Greeley and you don't get these very often, you may have to kind of refamiliarize yourself with the processes every time you do it. But the other thing that we're hoping through the webinar is it'll give you a chance to really look and see what your processes are before you get an appeal so that you know what needs to happen and you don't have any mistakes along the way. So when you send a taxpayer deficiency notice, it's important to look at that statutory section because there are some real specifics in there. For example, the notice has to be sent by certified mail and it has to set forth that time limit for filing a protest. The other thing that it really needs to do is, or that you really need to know is how fast those timelines move. One reason why I think you need to tell the taxpayer the time limit is because they only have 30 days. And so you tell them the time limit, and then if they don't meet it, that gives you a very good defense to their protest. But if they meet it, then you need to go through the process. The local government has 180 days to hold the hearing and issue a decision, which sitting here today sounds like a lot of time, but as we all know, we're busy in our practices, our clients are busy, and so 180 days can go pretty fast, especially when you're thinking everything that you need to do in that time period to get ready for the hearing. So Chuck and I encourage everybody to look at your local code and compare that to 29.2.1061, just to make sure that there's no changes that you need to your code, and that it's not confusing your local code and comparing that to the statutory site. You still have to follow those requirements set forth in the statute, and so you want to make sure that your code tracks that statute so that it's not confusing for you or the taxpayer. If you do update your code, or after this webinar you go look and say, wow, we need to do some updates, there's just a note, there is a section in the statutes that requires you to send a copy of your ordinance to the Department of Revenue after you do that. There's not really any penalty, so to speak, for that, but just a note about that. When you are setting the hearing or sending out information to the taxpayer, you want to make it clear to them if you don't intend to hold a hearing, or also if you need to waive the hearing, you can get an agreement in advance. And sometimes you might want to do that if there's really no issue that you think you can resolve early on, or if you just think it's an issue that needs to go to the Department of Revenue or the district court, you can do that. Denver has a form, I believe.
Yeah, we've attached a couple of forms. One is an agreement to extend the 180-day period, which if you're working with the taxpayer, they're gathering records, that's something that you may want to look at, as the statute does allow to go beyond the 180-day period if you get an agreement in writing. We also have a sample letter that if the 180 days has come and the local government does not intend to hold a hearing, we will send this letter out to the taxpayer, let them know that you have exhausted your local remedies. The 30-day period for you to appeal to either the district court or the executive director's office has started to run. So those are attached to the CML, I guess, with a website.
Right.
Yeah.
So now you've gotten the tax appeal, and it's within the time frame, and you're getting ready to go for the hearing. So the next thing, especially if you're in a smaller jurisdiction and you don't do these very often, you want to make sure you know who is going to conduct the hearing. In Greeley, for example, our code says that it will be the finance director or a qualified deputy, and in Denver they have a hearing officer that hears these hearings.
And our hearing officer, just to chime in a little bit, is an outside attorney. And the reason we've decided to go that route is in Denver, we have roughly 100 appeals filed per year. It would be too much for our manager of finance or our treasurer to hear these cases. But also, I think it creates an appearance of we're getting rid of some bias, because it would be a little bit hard to have an auditor go out, defend their audit in front of their boss and saying, look, I did it right. Where if you have someone else on the outside, looks a little bit more objective.
Right.
So that's one of the reasons we decided to go with outside counsel.
Right. And conversely, in Greeley, just for comparison, we get 2 or 3 appeals a year. And that's probably a big number for Greeley of appeals. And I think the bigger your jurisdiction gets, those numbers are going to go up. And so you're going to have to start being more familiar. And as Chuck and I prepared for the webinar, we've talked about this hearing officer finance director, and I absolutely agree with what he's saying, that if it's the finance director or a boss in your finance department that's hearing this, you do have to really make an effort to ensure that there is no bias and that you're really hearing what the taxpayer has to say. And so for that's why we say don't be a rubber stamp. So whether it's a hearing officer or a finance director, for example, you want to really help your client do a thorough review of the issue. There can be issues of law, there can be issues of fact. In Greeley, we have an outside auditor. We don't have any in-house auditors. And so it may be the first time that finance director is really taking a look at how the audit happened. And so it's a really good opportunity to make sure you're comfortable with everything that happened and resolve any issues or any appeals that you can ahead of time before it goes any further in the process. You need to determine what your hearing procedures are going to be. For example, in Greeley, we do allow hearings to take place by phone. In Denver, they do not. So really, you want to be consistent about that. So if you're not going to allow people to appear by phone, you want to know that and be consistent with that ahead of time, so it doesn't feel like you're treating one taxpayer different than the other.
And in Denver, because we have so many appeals, we actually have hearing rules. And we formalize those. They're on our website. So whenever we get an appeal from a taxpayer, we send a letter acknowledging the appeal. We also, in that letter, send a link to the website so the taxpayers know what the procedure will be at the hearing. Because we deal with so many, it's from our perspective, it's really important to have a defined process so the taxpayers, as well as the city, know exactly what is expected and what's allowed when you get to the hearing. Because as Stacey was pointing out, we want to make sure everyone's treated fairly, equally, and uniformly.
Absolutely. And I would say, even from a smaller town perspective, even if you do one a year, it's well worth your time to take the opportunity to find those hearing procedures, adopt hearing rules ahead of time, so that everybody knows the process, everybody knows the procedures when you get an appeal. Otherwise, you're just reinventing the wheel or remembering how things happen every time you get an appeal. So another thing that you need to do is determine the level of formality for your local hearing. You can do it informally. The statute actually indicates that it should be an informal hearing. Doesn't need to be a transcript, and there's no rules of evidence. Having said that, you do want it to be a fair process, so even if it's informal, even if it's just a meeting set down between the finance director and the taxpayer, you want to make sure you have a process in place.
Yeah, and I'll chime in here too. In Denver, we have the same hearing officer will hear hearings for sales and use taxes, but also at the same time, if there's lodger's tax, occupational privilege taxes, facilities development, admissions taxes. So we, even though the statute says shall be informal, we do record all of our hearings. We have a fairly formal process because once a decision is issued, the sales and use tax does have the procedures we're going to talk about in a minute about where you can appeal to, but we have defined process for appealing those other taxes. So it's important that we develop a record because the review of those is a 106A4, but we also have our own local appeals process for sales and use tax, which is a review of the record under CRCP 106A4 as well. So if you have your own local processes, you got to make sure you get those covered as well as those for the state appeal routes.
Right. I think that's a really good point. Greeley also tapes our hearings, but since we don't use a hearing officer, ours tends to be a much more informal sort of meeting. There is a case that talks a little bit about this level of formality and says that, yes, you can have an informal process, but one thing you can't do is you can't require more than the statute specifies. So in this Parker case, they had required an informal meeting and then a more formal hearing, and what the case says is you can't do that. Okay, so your process of doing the local hearing is part of the taxpayer's exhaustion of remedies. And some of the taxpayers that come before you for a hearing, that's all they really want to do is exhaust their local remedies. But it does give the local jurisdiction the opportunity to kind of narrow the issues or resolve some issues before it goes forward for further appeal, if that's the way it's going to go. So you need to make sure that you are doing everything you need to do so that the taxpayer exhausts their local remedies. The taxpayer's responsibility is really to request the hearing in writing before the local government within the right time period. then the local government needs to have the hearing and issue a written decision within 180 days. That's one way that the local government can exhaust the local remedies. Or the taxpayer and the local government can agree in writing that no hearing will be held and no decision will be issued. So you might want to do that in certain cases where you just don't see any opportunity to resolve any issues, any opportunity to get the matter settled, and nothing that the local government really is going to see to change with the appeal.
Exactly, and I think a follow-up on that, there are two additional examples I would give of that is, if there's just purely legal issues, there are no factual issues. If someone's challenging the constitutionality of a particular provision, it really makes no sense to have a local hearing. Oftentimes in those cases, we'll agree to go ahead and exhaust them and let them move on. Another example would be in cases where there are intercity claims for refund. So if you're auditing a taxpayer that's operating in a number of jurisdictions, they provided taxes to another jurisdiction, it's going to be difficult at a local level to get those other jurisdictions into your local government to have a hearing held. And the state process does provide for intercity claims at the executive director. So in those types of cases, it makes a lot of sense to agree with the taxpayer to go ahead and allow them to move on so they can get their issues resolved.
Right. That's a really good point. The intercity claims, I definitely don't think that would be something you'd want to try and do at the local level. So you could also, in some cases, I'm not sure you would want to do this, but if you do, if 180 days passes since the taxpayers requested a hearing, you could not take any action. So if nothing happens, then the taxpayer can go ahead and appeal that. And then the other option is that you do notify the taxpayer that you're not going to have a hearing. So you don't necessarily have to agree on that, but you just say, hey, we're not going to have a hearing.
Yeah, I think to the point you were getting to is, if the 180 days comes and goes and nothing happens at all, in Denver we take the tack of we never leave it open. Right. And by that I mean, once the 180 days passes, if we've not held a hearing and issued a decision, we're going to do one of two things. We're going to either get an agreement in writing to extend the 180-day period and reschedule the hearing to a later date, or we will send an exhaustion letter saying you have exhausted your remedies, you move on. Otherwise, you run the risk of potentially a taxpayer sitting out there for a year or 2-3 years. Nothing would prevent them from filing an appeal sometime down the road, because under the statute, the way it's written currently, they can appeal any time after the 180 days is run, and there's no time limit when they have to file their appeal. So we want some certainty. So we send those letters out and get the clock going so they can move on and we have certainty.
And I actually think that's a really good idea. Chuck's attached the Denver form, and I would encourage everybody to take a look at that. I know that I definitely am going to incorporate that for Greeley. I think the 180 days, just letting it pass, and then somebody requesting a hearing, that strikes me as just something that might happen inadvertently, where you just don't get the hearing done for some reason. And I agree with Chuck. What I've seen happen is that staff will be sort of informally trying to negotiate something, that 180 days passes and then nothing happens, and it really could extend the life of an appeal for a taxpayer really much longer than you want it to.
Yeah, I know our practice is within a month of that 180-day time frame, we start talking with the auditors and with the taxpayers and saying, look, the time frame's coming up. We need to make a decision. Are we going to have a hearing, or do you guys want to extend it because you guys are working together cooperatively, you have more records to provide, you can't get them done in that month period? Or alternatively, are you ready just to move on, in which case we can send an exhaustion letter? But yeah, we plan ahead. We always calendar that stuff and try and keep things moving in the right direction, because we don't want things to linger.
Right. And I think for the smaller jurisdictions, it is a harder process in the sense of neither you nor your clients are particularly familiar with the process or have a particular expertise in the process. And so the more you can formalize things, get templates, and do all of this in advance, the less what's going to happen is that you as the attorney find out about the appeal well into the 180 days. I know sometimes our clients get busy and they're not really recognizing the importance of an appeal letter that comes in. Not all the taxpayers are going to specifically put on in big bold type across the top of their letter, this is an appeal. It's more like I'm just sending a letter and I'm really upset about this assessment that I got. But we need to teach our clients to recognize those letters for what they are and get those timelines going. So I think the more you can get in front of this and adopt the procedures and the forms, it's going to be better, especially in a smaller jurisdiction.
Yeah, and the larger ones like Denver, because we do get so many appeals, we have we have a hearing coordinator down in our Department of Finance who will get those up to us regularly and timely. And we also have monthly meetings with our Department of Finance to go over all of the hearings that are in process and what stage they're at and what we need to do with each of them. So the communication is just really the key, making sure your client knows what an appeal letter is and to make sure they get them to the attorney as quickly as possible.
Right. And some of you may be sitting out there like I am jealous of Chuck having a hearing coordinator. I think sometimes I am the hearing coordinator. But, I think that we can learn a lot from jurisdictions that are bigger that do more of these appeals. So we've sort of alluded to this, but there are multiple avenues for a taxpayer to take to appeal, to do a further appeal once they've exhausted their local remedies and the local appeal is finished. And we're going to kind of go through those. There's basically three options. One is an appeal to the State Department of Revenue, and we'll talk quite a bit about this, but that is a de novo appeal. Second option is a taxpayer, provided it's just one jurisdiction, can appeal to the district court, and that's de novo. And then you may have in your code local appeal procedures. Chuck indicated that Denver has a 106 procedure and Greeley does as well. So a taxpayer could avail themselves of those local procedures that are set forth in your code.
Okay, I think the first option we're really going to talk, I guess, in depth about would be the appeal to the State Department of Revenue. Once a taxpayer has exhausted their local remedies, they have 30 days in which to file a written appeal with the State Department of Revenue. Just an interesting, I guess, tidbit to mention is the state statute does not require the taxpayer to serve the local government with a copy of the appeal. Some taxpayers, and in particular attorneys that we deal with routinely, will send us courtesy copies of the appeals that they file with the State Department of Revenue. Others do not send us copies of those appeals, and it may take some time. You know, it could be a month, 2-3 months down the road before you found out if a taxpayer ended up appealing from your local jurisdiction. If you haven't got a courtesy copy, usually the first time you'll find out an appeal has been filed is the Department of Revenue will send the case off to a tax conferee, and that conferee will send you a written letter saying the case has been referred to the conferee. It'll give the contact information for the conferee. It'll also direct the taxpayer to go ahead and schedule an informal conference so the parties can get together in front of a conferee to talk about the case. I think the letter generally says the taxpayer is supposed to contact the conferee within 30 days of receiving the letter. That's just to get it scheduled. When you actually will have an informal conference really varies depending on the circumstances of your case. If it's a case where the taxpayer has been cooperating and is trying to provide records to your auditor, oftentimes the tax conferee will let the informal conference sit for whatever time the taxpayer requests. It could be 6-8 months a year before you have an informal conference. As long as the parties are cooperating and updating the tax conferee, they're usually happy to let the parties work together. If it's a situation where it's not really a whole lot of factual dispute out there and it's more of a legal issue, they'll go ahead and get those things scheduled fairly quickly within a month or two of receiving that letter.
And some of you, like Greeley, are probably familiar with the AT&T tax appeal of a few years ago, and I think that sat at the Department of Revenue for years, several years. I don't
Yeah.
know if that's typical or seemed like a kind of a strange situation.
It really depends. If it's just a single local government and a single taxpayer, they have a tendency of moving a little bit quicker. If it is an intercity claim for a refund, they do usually take longer. I've had a couple that have open ones that are probably 7 or 8 years old right now. So it can happen. I think that's probably atypical, and I think the Department of Revenue is trying to get those things moving faster. But with an individual taxpayer, usually it's quite a bit quicker than that. The purpose of the informal conference is to determine whether there are opportunities for the parties to work together to narrow the factual or the legal issues, and whether or not the case should be referred to hearing. If you've been working on a case and have been involved at the local level for a while, it's fairly rare that you really learn anything new at the informal conference. With that said, there can be some value to them, and they can be productive. A lot of times when a meeting is scheduled, and if you've been waiting for records and the taxpayer hasn't provided them, they finally realize we have a deadline, we need to get moving and get you those records. If they get to the informal conference and you still don't have the records, the good thing is the tax conferee will impress upon the taxpayer that if you hope to succeed at a hearing, the burden's on you. If you don't have any records, you probably aren't going to have that great of a case. So that will oftentimes incentivize them to get moving. Also, if it's a case where it's just legal issues, that's good to know too, because if they're just purely legal issues, usually the tax conferee will go ahead and refer that directly for a hearing and keep it moving in the right direction. If the tax conferee refers the case to a hearing, you will receive a letter. It's a pre-hearing order directing the parties to file a number of things: an entry of appearance, so they know who the attorneys are, an administrative pre-hearing data certificate, and we've listed on a slide here each of the items you need. You need to list all the legal issues the taxpayer has, the amount of the tax, penalty, interest, any relevant facts in support of their case, as well as relevant legal authority, whether it's case law, statutes, codes, whatever. And they also require a position statement that kind of summarizes what the case is. They're trying to basically get it ready for the executive director to have a good summary of what's going to go on. And it's really important that this exchange is done, I guess, with some effort, and you're careful in how you prepare it, because once you get to a hearing, the hearing officer is not going to let you raise issues that were not raised in your pre-hearing data certificate. They're not going to allow you to bring in witnesses you have not listed. Similarly, they're not going to let you bring in documents or exhibits that you have not listed. So it's really important that you take that the time to do that. It is a staggered exchange. Usually the taxpayer has 45 days from the date of the letter to get theirs in. The local government only has 20 days. Just keep in mind that they fairly liberally grant extensions of time for the local governments to do this, because they know that 20 days isn't much time. I've had a number of conversations with them over the years and asked them if they would move it to a month, and they said no, but they grant my request for an extension every time I file one. So you have additional time if you need it. But it is important to make sure that you have your case fairly well in order at that point in time. Otherwise, you're going to be hampered by the time you get to a hearing.
And I just want to second that sort of on behalf of the smaller jurisdictions. If you had an informal hearing or no hearing for your local appeal, as you're moving down this path for a Department of Revenue appeal, this is really the opportunity that you need to take to have your meetings with your clients, really gather the documentation they have and organize that documentation. And the timeline, in a sense, will move fast, depending on how informal you treated the local appeal, or if you didn't have a hearing, because really that's your opportunity that you're getting your ducks in a row. And so once you see what the taxpayer's position is, you really need to be prepared with a really good pre-hearing statement, because that's really how you're organizing your case. And then the second sort of benefit in my mind is that you get a second chance to narrow the issues or get the case resolved if you feel like that's something you can accomplish.
Oh, absolutely. And I think your point of summarizing your position is really, really critical, because if you know what your position is and where you're coming from, then it's just a matter of backing in what exhibits do I need to prove that point? Who are the people I'm going to need to testify to that? So it is really important that you map out where you're going early on. Otherwise, like I said earlier, you're going to have some trouble when you get the hearing. It is a de novo hearing. It is without regard to the decision of the local government, and I guess it's kind of key point, and I think it's maybe fairly obvious, but if the local government lost an issue at their local hearing, it's a brand new hearing. You can fight that issue again. You're not precluded from raising that issue once you get to the executive director. Taxpayer does have the burden of proof. It is in front of a hearing officer. They usually record it. I don't recall ever seeing a court reporter at that level. And as I kind of indicated before, you're limited to the issues, the witnesses, and exhibits that you exchange at your pre-hearing data certificate. So you've got to make sure you get those in. It is an informal hearing. With that said, it is run somewhat similar to a lot of administrative hearings, court proceedings. Since it's a taxpayer's burden, they will go first. They will present their witnesses. The local government will have the opportunity to do cross-examination. The hearing officer may ask questions as well. Once they're done with their case, the city will put on, or the local government will put on their case. The other side will have right of cross-examination. Here again, the hearing officer can ask questions. In my experience, it's fairly typical that the parties file written closings, which is basically a written summation of what went on at the hearing, tying together the testimony and the exhibits to your earlier position statement. And then there's a specific process in the state statute dealing with intercity claims that we wanted to treat a little bit separately, because up until now we've been really talking about one local government and one taxpayer. But if we have a situation where there is one taxpayer and the audit overlaps with multiple jurisdictions, the statute does authorize the taxpayer to appeal to the executive director and request that the executive director join the other jurisdictions. Statute does say that the taxpayer is not required to file a claim for refund with those other jurisdictions. That will all be handled before the executive director. If the Department of Revenue or the executive director finds that the taxpayer did pay all the tax at issue, but to the wrong local government, the taxpayer will be relieved of the amount of the tax that they paid, interest, and penalties. So what we have found, I guess, in Denver anyway, there are a number of taxpayers that overlap jurisdictions. For the most part, I think most taxpayers try and do the right thing. But occasionally they do get taxes to the wrong jurisdiction. We have found a few taxpayers that we have found that they have had problems. We've notified them. They've been audited many times over, and they just don't correct the situation. And the reason they don't is they always tie back to this particular statute saying, look, we paid somebody tax. We know we did. We can prove we did. You guys go figure out who the heck actually owed the money, and they walk. So we have lobbied, and I think through CML extensively over the years to try and get that changed. In a few minutes, we'll talk about one thing that we can do to help our efforts if that happens in your jurisdiction.
And I think this is an area that a lot of our clients find confusing, and so it's probably a lost opportunity to really either get people paying to the right jurisdiction or recover some revenue that you should be receiving that you're not receiving. And so it's really a good opportunity to have some education with your client of this process and of this issue so that you can either recover the revenue or work with the other city to make sure the taxpayer is paying to the right jurisdiction.
Exactly. Here again, I guess following up where I left off, if the Department of Revenue finds that the taxpayer overpaid the tax, the local government is required to refund the overpayment to the taxpayer with interest. On the other hand, if the Department of Revenue finds that the taxpayer underpaid the taxpayer is required to pay the underpaid amount to the appropriate local government. And sometimes this can get a little bit complicated in the intercity claims because one local government's doing an audit. It's not atypical for the other joined local governments to not necessarily agree with the audit methods and procedures and the amounts that the auditing jurisdiction came up with. So oftentimes it's a little convoluted and difficult to figure out who actually owes what. That's why it's really important for your auditor to document what they did, how they did it, and so they can quantify how much each jurisdiction in their mind actually owes, whether it's a overpayment or an underpayment.
Right.
And state statute also talks about if the Department of Revenue finds that the taxpayer paid the tax to the wrong local government, the local government that erroneously received the tax is required to pay the correct amount to the local government that should have received it with interest. So this is really a process, like I talked about a second ago, that can benefit taxpayers that choose to maybe not necessarily do things right or correct their ways.
Right. And if you're the city that's trying to collect the tax, you're really trying to collect that from the taxpayer. It may make you unpopular with your fellow sister cities if they have to repay to you with interest. But at the same time, I think the whole process really, through CML or through these other groups that are clients and we are involved in, we really need to make the effort to make sure the tax is getting paid to the right jurisdiction.
No, I agree. And I think that's one thing that we always are cognizant of is we are in a particular region. We deal with the same local governments over and over again. So we try to the extent possible to work as cooperatively as we can with the other jurisdictions because we don't need to make enemies with each other. We're not the ones that caused the problem. We should be working together to try and solve the problem. One thing about the state statute and the intercity claim piece that's been, I guess, an issue for a number of years is the statute's silent regarding the statute of limitations. And this comes up almost in every intercity claim case at the executive director because most local governments have a 3-year statute of limitations. By the time the local government is joined at the Department of Revenue, it's not uncommon for that local government's 3-year statute of limitations to have run. But you have to keep in mind, most jurisdictions do a 3-year audit, and they do this sometime after the period's done. They issue an assessment. You've gone through the local procedures. You appeal to the executive director. It might be 2, 3, 4, 5 years after your statute of limitations is run by the time you're joined. Most often, the local governments will argue, hey, our statute of limitations is run. You can't require me to refund any money. We're off the hook, so let us walk. Taxpayers, of course, argue, well, the statute's silent. Your statute of limitations doesn't apply. You need to be here. In 2014, the Court of Appeals heard the Quest Corporation versus Northland case, and the Court of Appeals held that the joined local government's statute of limitations is applicable, and basically said that in that case, the joined local jurisdiction cannot be required to refund taxes. It put the taxpayer in a situation of, well, gave the perception of them paying the taxes twice. Whether or not that's actually true, I guess I would disagree in many instances because more often than not, these are the vendors who've collected the tax from someone else and remitted it, so they're really paying it once. But the perception was there that they're paying the tax twice. As a result, a number of the vendors in the metro area got together and proposed legislation this last session, or current session, I guess, Senate Bill 17-112. That Senate bill was signed by the governor on April 18th of this year. It effectively overrules the Quest decision. The statute 29.2.106.1 paragraph 5 was amended to clarify that the joint local government statute of limitations will not bar the remedy provided in the state statute. So the local governments can never, no longer use the statute of limitations as a defense in those particular cases. There was one, I guess, saving grace in this legislation. For taxable events occurring after January 1st of 2018, the taxpayer cannot take advantage of the intercity claim remedy in this statute, if it receives a written notice from a local government that the taxpayer must pay the tax to the local government for a particular taxable event, and if the taxpayer fails to comply with the local government's written instructions more than 90 days after it receives the letter. So if the local government, by way of example, sends a letter to, I'll just say, a company that rents heavy equipment, and says, if you rent it in Denver and the taxpayer or the one who's leasing the equipment picks it up in Denver, the money is due, the rent, tax is due Denver. If the renter of the heavy equipment ends up paying the tax to the jurisdiction where the heavy equipment ends up, they've not complied with that jurisdiction's written instruction. In that particular case, they can't take advantage of the remedy in the state statute. So one thing that Denver is looking at is putting together some written instructions for situations where we see typical intercity claim cases, send them out to all the vendors so they will now have a written letter on file so we can cut off a lot of those intercity claims going forward.
That's a great idea.
Appeals from the Department of Revenue can be taken within 30 days after a final decision by the Department of Revenue, and they would appeal de novo to district court. So in effect, it would give the taxpayer, this is their third bite at the apple. You've had the local government, you've had the executive director, and now you get to do it once more in front of the district court. If the local government is the one that's appealing, the taxpayer has the burden of proof for all factual matters. The local government has a burden of proof for legal matters. And of course, if the taxpayer is the one who's appealing, they have a burden of proof for both. And the hearing would be, a trial would be the same under the rules of civil procedure as you would normally expect. Rules of discovery, trial management orders, case management orders, whatnot.
And so we did also mention this, but another option that the taxpayer can take is, instead of making an appeal to the Department of Revenue, they can go directly to the district court for an appeal if there's only one local government involved. So if it's just you and the taxpayer can make that decision. I don't want to go through a hearing at the Department of Revenue. I want to go directly to the district court. And that's, again, it's de novo, and the rules of civil procedure and evidence apply. So if the taxpayer is kind of looking for a more formal, full-blown hearing, they may choose to skip that Department of Revenue hearing and go straight to the district court.
And we find that a lot, especially when there are only legal issues involved with the case, not so many factual issues, because you don't necessarily want to rely on an administrative hearing body to make a legal decision. They would go straight to court.
Right. And in terms of venue, I think it's just a note that the venue is to the jurisdiction where their principal place of business is. If they don't have a principal place of business, it's going to be to Denver. So if you're a smaller jurisdiction and you're dealing with a bigger company, you're going to be going to Denver to have this district court appeal. Good for Chuck, bad for some of us that are a little bit further away. So then the other option that you can take, and Chuck mentioned this, and I did too, that if you have an appeal procedure in your ordinance, in your municipal code, you can go that direction too. So it's usually a 106 appeal, and that's going to vary by local government, but as I said, both Denver and Greeley have a direct 106 appeal, and a lot of you probably do as well. And
that's why, since it is a review of the record, you really got to make sure you develop a record and you have a recording. Until recently, Denver actually had court reporters at our hearings for this very reason. We do now do electronic recordings, and if there's an appeal under 106A4, we'll have it transcribed. But surprisingly enough, we actually have a fair number of 106A4s.
Right. Well, and I would say my feeling is the less formal your local appeal is, the less chance that a taxpayer is going to avail themselves of a 106 appeal, because they're going to perceive, I think, the less formal hearing as just a rubber stamp of whatever the sales tax manager or the auditor has said. and they're not going to want a review on a pretty minimal record that's developed at an informal hearing. So
Exactly.
I can't think of a single time Greeley's actually had a 106 appeal on a sales or use tax issue. And I think you just said that you actually have them.
Yeah, it's not every year, but it might be at least every other year we get a 106A4
Right.
appeal.
So if you develop a pretty good record at the local level, maybe the taxpayer's trying to save some money and just get a review by the district court versus doing another full-blown hearing.
Exactly.
So that's all that we have to present, but we'd be happy to take any questions that anyone might have.
Excellent. And while those questions are coming in, I do want to give you a couple of quick reminders. So 2 general credits were approved, 2 CLEs. The course ID number 757893. And of course, go to www.cletrack.com, click on CLE transcripts, log in, and enter that information. If you need a hard copy of the notice of accreditation, just email me and I'm happy to send it to you, lwhite@cml.org. Again, this and all of the materials are going to be saved, the handouts and the presentation at cml.org under training materials. Do we have any questions?
So we have one question. I'm going to read it and then I'm going to see if Chuck can answer first. So the question is, do you believe a municipality can appeal an adverse decision from its own hearing officer or finance director?
Denver's code provides that either party can appeal from a decision of the manager of finance. I can say I don't recall having that happen. Usually if we lose at the local level, which is often rare, I think we'd rather lose at that level and move on. I think learn from what we've made mistakes of and go on. But our code certainly provides for that.
And I just think this is another good opportunity to talk about informal versus more formal hearing. I think in Greeley, if we were doing an appeal to our director of finance and she determined that the appeal was correct, I don't know who would make the decision to appeal because really the director of finance is your client at that point. But if you have a more formal process and you're going through a hearing officer, I think you may have a client who says, yeah, that's not a correct decision and we want to appeal that. So it may make a difference who your client is and the level of, I guess, formality that you have in your hearing. And I would chime in on this. So we have a comment, just a big congratulations to Chuck on the recent Expedia case. And if you haven't read that case, it really is a great read, and it's a really big win for Denver, and I think for all jurisdictions in Colorado. So hooray to Chuck. Yeah.
Well, thank you.
So another question, when a local appeal is provided in the code, is that at the option of the taxpayer? Put another way, do they have a choice then between a DOR, district court, or 106 appeal?
If I understand the question correctly, once you've had your local hearing, it is the taxpayer's choice whether or not they want to go to the State Department of Revenue, to the district court, or to local appeal remedies.
Right.
Yes.
And in Greeley, I don't think we've done enough to where I would really have a preference, but it is sort of always interesting when you get an appeal. Are they going directly to district court or are they going to the Department of Revenue? But maybe you have an opinion, Chuck, if you want to share whether there's pros and cons to a district court appeal versus a Department of Revenue appeal.
You know, I see more go to the Department of Revenue than I see go to the district court. But with that said, I have 3 district court ones right now, and I have probably 12 executive director appeals right now. More often than not, I do see the executive director, especially in cases where it's a dispute, a factual dispute, taxpayers trying to get records. Basically, they're appealing to the executive director knowing that it's going to take a little time before they have a hearing. It'll give them more opportunity to get the records they need to get to the auditor. And more often than not, if the records are helpful, we're more than willing to adjust our assessments to reflect that particular I guess, warranted adjustment. One thing I do wanted to chime in a little bit on to that same question is it the taxpayer's option? In the past, Denver did in our code require as a default that all appeals go under the local remedy if the taxpayer did not list in their petition to the local government which one they wanted. Just a side note, we lost on that in district court, so yeah. Court said that we weren't compliant with the state statute, so you might want to we have since changed our code and made it perfectly clear it's a taxpayer's option, but for about 15 years, we had to default our local remedies, and we were told that wasn't acceptable.
So the next question is the Expedia case published already? Where can it be found? I know I received it through our finance department because CML sent it out, I think, to most of the jurisdictions.
It is published. It's on the Supreme Court website. You can find it on Lexis or Westlaw as well.
So next question, does anyone assess tax on a furniture store's display of showroom floor models where the floor models are not generally for sale but are assembled and used as a prop to sell other items out of a warehouse inventory? I would say Greeley doesn't, but then again, we don't have many furniture stores, and so we're really dealing usually with the American. So I don't know about Denver if you've ever addressed that issue.
Reading the question one more time to make sure I understand it. If it's pulled out of inventory and if it's for the business's own use, depending on the circumstances, one could and you don't end up turning around and selling it, I think you could argue a use tax is probably due on it.
Right.
Because it's inventory for their own use. I wouldn't say a sales tax.
No, I think it's probably a use tax. Next question, if the taxpayer has missed the 30-day window to protest an assessment and remits payment with a refund request, can the city deny on the basis that they waived the right to protest, citing Denver's United Airlines case?
Yes. We've had that happen many times, and no, you get one bite at the apple. If you paid it and you come back later and ask for a refund request, we would deny it.
Yeah,
absolutely.
I think
we have.
Too. Yeah.
And we've had that appeal to the executive director that upheld that decision.
But I can see the argument, so it's almost that they're trying to extend their appeal time by paying and then making a refund request instead of an appeal directly of the assessment.
Yeah.
So regarding intercity claims, what if the tax was collected by a vendor of the taxpayer being audited, but it was not remitted properly and you don't know what happened to the tax? Oh, I see. Okay.
Well, I guess there's a couple of things. If it was remitted to a vendor, first thing Denver would look at is that vendor a licensed vendor? And we would look to see, have we audited that vendor and can we verify that those taxes were paid to Denver? If we cannot verify that they were paid to Denver, or if it was an unlicensed vendor, we would hold the person responsible for the tax under Tobin versus Weed.
Okay, next question, and thanks to Chuck for answering the bulk of these questions. With respect to Senate Bill 17-112, written instruction, is Denver thinking that a proactive written instruction that there is an obligation to pay may be sufficient instead of meeting a specific assessment?
I think that's what we're contemplating at the moment. I'm not sure we've totally thought that through, but that is, I think, the direction we're heading.
And I do think that's a good idea to send out so that nobody can argue they never received the written instruction. Is basically the thinking there.
Yeah, I think we're going to target those cases. We know which ones we get intercity claims on fairly regularly.
Right.
Target those particular businesses and send out those letters to all, that entire industry, not just to one taxpayer, but to all of them. So they all are clear on this is the way we expect taxes to be paid.
Right.
Exactly.
Instead of doing it one by one as you do an assessment.
Well, exactly. We see that in a lot of rental type businesses, or I don't want to necessarily say a particular taxpayer, but ones that might have big furniture stores that sell and throughout the metro area that may deliver as opposed to have pickup of the furniture. I think we would probably hit those, as well as large equipment rental places. Yeah.
This is Diane Criswell. Follow-up question to Chuck on Senate Bill 112, which is, do you think that it'll be easier to implement for municipalities that have adopted the hold harmless and the address locator database?
Oh, absolutely. Yeah, no. Oh, sorry about that. Denver has adopted the hold harmless statute. I think we were one of the first jurisdictions that did that, and I think that's absolutely correct. That if they have a hold harmless and they're not using it, and if you have the Senate bill saying that you've received instructions and you still don't do it right, I think the taxpayer will be in a difficult position to say that they should be off the hook in those situations.
Right. Are you aware of practice or authority for DOR to impose Tabor interest?
I haven't come across that. Have you?
No.
Okay.
No. So the answer is aware, no. Appreciate the thank you, Rachel. Rachel says thank you for the training, and actually Rachel's the one that suggested that I do the training, so thank you, Rachel, for that.
Great. Final note, CML's annual conference, June 20 through 23rd in Breckenridge. Early registration rate deadline, May 12th. And then our fall seminar on municipal law, October 6 through 7 at Cheyenne Mountain. Registration will open soon, but just wanted to make sure that was on your calendar. Any other questions? Okay.
No more questions?
All right. Well, thank you so much to our presenters. We really appreciate it. Thank you all for participating. Have a great afternoon.
Thank you.
Thank you.